on September 16, 2004, the San Francisco Chronicle published an op-ed piece written by an 85-year-old U.S. citizen born in Oakland, California. He wrote as follows:
Fears and prejudices directed against minority communities are too easy to evoke and exaggerate, often to serve the political agendas of those who promote those fears. I know what it is like to be at the other end of such scapegoating and how difficult it is to clear one's name after unjustified suspicions are endorsed as a fact by the government. If someone is a spy or a terrorist, they should be prosecuted for their actions. But no one should ever be locked away simply because they share the same race, ethnicity, or religion as a spy or terrorist. If that principle was not learned from the internment of Japanese Americans, then these are very dangerous times for our democracy.
The author of the piece was Fred Toyosaburo Korematsu. This morning, we will tell you his story through reenactments of legal proceedings drawn from transcripts, court decisions, and other contemporaneous documents.
Fred Korematsu was the third of 4 sons of Japanese immigrants born on January 30, 1919, with the name Toro Saburo, Saburo meaning third son. At elementary school, one of his teachers asked if he would like to be called Fred. He liked the name and was Fred forever after. He and his brothers attended school and joined the Boy Scouts. His parents established a flower business, and the family became active in the San Lorenzo Japanese Holiness Church. Years later, Fred recalled,
When I was in school, we started each day with the Pledge of Allegiance to the American flag. I studied American history and the Constitution of the United States and believed that persons in this country were free and had equal rights.
By 1940, the Japanese Empire was pursuing war with China, and Germany had invaded Poland. It was the beginning of what would become known as World War II. In 1940, Congress established the first peacetime draft, and Fred, at age 21, registered on the first day. He was classified as 4F due to a gastric ulcer. Eager to support the war effort, he got a job in a shipyard, but was soon fired due to his Japanese ancestry. Shortly thereafter, while relaxing with his Italian-American girlfriend in the hills above Oakland on December 7th, 1941, Fred heard on the radio that the Japanese had bombed Pearl Harbor.
exclusionists who had for decades decried the yellow peril posed by Japanese immigrants were quick to call for wholesale removal of Japanese Americans from the West Coast. Others joined in. On January 29, 1942, syndicated columnist Henry McLemore wrote as follows:
I am for the immediate removal of every Japanese on the West Coast to a point deep in the interior. I don't mean a nice part of the interior either. Hold them up, herd them up, pack them off, and give them the inside room in the Badlands. Let them be punched, hurt, hungry, and dead up against it. Personally, I hate the Japanese, and that goes for all of them.
Lieutenant General John L. DeWitt, head of the Army's Western Defense Command, was convinced that the Japanese were naturally treacherous and advocated for their removal. Some civilians within the government urged caution, including Attorney General Biddle, FBI Director J. Edgar Hoover, and Eleanor Roosevelt. Pressed for a written recommendation, DeWitt wrote to the Secretary of War on February 14th as follows:
In the war in which we are now engaged, racial affinities are not severed by migration. The Japanese race is an enemy race, and while many second and third generation Japanese born on United States soil, possessed of United States citizenship, have become Americanized, the racial strains are undiluted. It is therefore follows that along the vital Pacific coast, over 112,000 potential enemies of Japanese extraction are at large today. There are indications that these are organized and ready for concerted action at a favorable opportunity. The very fact that no sabotage has taken place to date is a disturbing and confirming indication that such action will be taken.
On February 19, 1942, President Roosevelt signed Executive Order 9066, giving DeWitt the authority to remove the Japanese. Although initially concerned about the constitutional implications of any wholesale evacuation, Secretary of War Harry Stimson gave DeWitt the power to implement the order the next day. A series of public proclamations followed. The first announced that all persons of Japanese ancestry would be removed from Military Area Number 1, an area consisting of parts of Washington, Oregon, California, and Arizona. Public Proclamation Number 3 imposed a curfew on all persons of Japanese ancestry and other enemy aliens. Congress, for its part, passed Public Law 503, making violation of any such military orders a crime.
While Fred's family chose to comply with the evacuation order, Fred set a different course. He wanted to stay with his girlfriend. At Ida's suggestion, he tried plastic surgery, and he altered his identification papers. On May 8, 1942, his family reported as ordered by Civilian Exclusion Order Number 34 and were imprisoned in horse stables at the Tanforan Racetrack Assembly Center. On Memorial Day, May 30th, 1942, while walking with Ida in San Leandro, Fred was arrested and imprisoned.
A young attorney, Ernest Bessick, visited him in jail and asked if he would be willing to be the ACLU's test case. Fred agreed. Fred was then transferred first to the Presidio Stockade in San Francisco and next to Tanforan, where he was chastised by his parents and brothers for his arrest and the shame he had brought on his family. In September 1942, the family was moved to the more permanent concentration camp in Topaz, Utah, where Fred was viewed by his fellow inmates as a criminal and as someone who was more white than Japanese.
While Fred was still at Tanforan, Bessick introduced him to attorney Wayne Collins, who filed a motion to dismiss the charges against Fred in June 1942, raising a host of arguments, including deprivation of constitutional rights. The motion was denied.
Please be seated.
The case was tried on September 8, 1942, before the Honorable Adolphus St. Shore, United States District Judge for the Northern District of California. The government was represented by Assistant United States Attorney A.J. Zerpeli, and Fred was represented by Collins. Fred pleaded not guilty, and both sides waived jury. The trial was not transcribed, but we have reconstructed the testimony from the Supreme Court record.
The government called only one witness, Special Agent Oliver Mansfield of the FBI.
Agent Mansfield, will you tell the court how the FBI became involved in this case?
Yes, sir. We received a report from the San Leandro Police Department that Mr. Korematsu was arrested on May 30th, 1942, as a Japanese remaining in a restricted area.
And did you become involved in the investigation?
Yes, sir. I interviewed the defendant the day after he was arrested, and again the next day. He admitted that he was of Japanese ancestry and that he remained in the area even though he knew it was prohibited.
Now, was the defendant in a restricted area when he was arrested? That is, an area from which all persons of Japanese ancestry had been ordered excluded?
Yes, sir.
When you interviewed the defendant, did you show him any documents?
Yes, sir. When the defendant was arrested, he had in his possession a draft registration and a notice of classification card. I showed him the certificate, which bore the name Clyde Sarah, and I asked him about that.
How did he respond?
He said he had wanted to remain in Alameda County because of friendly relationships with people there. He said he considered himself an American and did not want to be evacuated. He said that he wanted to disguise his identity because his name, Korematsu, would give him away as Japanese, and for that reason, he had adopted the name Clyde Sarah.
Collins did not cross-examine Mansfield.
The government rested. Collins moved to dismiss the charges.
Your Honor, as we argued in our demurrer, Executive Order 9066 is on its face and as applied to this defendant unconstitutional. The executive order denies the citizen and to this defendant as a U.S. citizen the privileges and immunities of citizenship, including freedom of movement, the right to live and work where he pleases, the right of free speech and assemblage. It operates to deny Mr. Korematsu his liberty without due process and equal protection of law in violation of the Fifth Amendment.
The motion is denied.
Collins proceeded to call the defense's only witness, Fred Korematsu.
Mr. Korematsu, will you tell the court where you were born?
Oakland, California.
And how old are you?
I am 23 years old.
Where do you live?
I live with my parents in Eads Street, Oakland, where I've resided for 23 years.
Well, where is your family now?
They're at Tanforan Assembly Center.
And where were your parents born?
They were both born in Japan.
Do you have siblings?
Yes, 3 brothers. We were all born in Oakland.
Can you please tell the court your educational background?
I went to grammar school in Oakland and graduated from the Castlemont High School in Oakland. I attended Los Angeles Community College for 3 months in 1938, where I studied chemistry. I had to abandon my studies because I couldn't earn enough to support myself.
What happened then?
I returned to work for my father in his nursery in Oakland.
When your family was required to evacuate, what did you do?
I stayed in Oakland to earn enough money to take my girl with me to the Middle West. Her name is Miss Ida Boitano. She is a different nationality, Italian.
Are you an American citizen?
Yes, I have never renounced my American citizenship.
Now, Mr. Korematsu, are you willing to serve in the U.S. war effort?
As a citizen of the United States, I am ready and willing to bear arms for this country. I registered for the draft, but because of physical defects, I was rejected by the Army. So I studied welding and worked in a shipyard on ships used in the war effort. I became a foreman in the shipyard, but was eventually discharged because of my Japanese ancestry.
Are you loyal to any country other than the U.S.?
No, sir, I am not.
Mr. Korematsu, are you familiar with the Japanese language?
No, sir. I never attended any Japanese school. I cannot read Japanese. I understand a little when it is spoken. I speak it in broken English. As my mother does not understand my broken speech, my older brother interprets my English into Japanese for her.
Mr. Zerpoli, you may cross-examine.
Thank you, Your Honor. Mr. Korematsu, was your birth registered with the Japanese government for dual citizenship?
No, sir. There was some discussion of registration long ago. My father said he didn't care, and my brothers said there was no sense in it. My brothers and I, naturally, we belong to this country, and we don't know any other country.
Now, you've never served in the U.S. military, have you?
I was willing to enlist in the Army, but I had stomach ulcers, and the doctors told me I was not fit for service. When I was rejected for the draft, I spent $150 out of my own pocket to study welding, and then went to work in the shipyards as a welder.
You indicated in your written statement, sir, that you intended to give yourself up. Is that correct?
Yes. That is why I was near the assembly area in San Leandro.
But you did not give yourself up, did you?
No, I was arrested before I could do so.
In fact, you assumed the name Clyde Sarah to escape arrest and registration, didn't you?
Yes, I sought to delay registration so that I could be with my girlfriend a little longer, but later thought better of it. On May 30th, I was intending to register.
And at the San Leandro Police Headquarters, you used this fake name, Clyde Sarah, and you told the officers that your parents were of Spanish and Hawaiian ancestry and had died in a fire. Isn't that right?
Yes, I did those things.
And you also had surgery in an attempt to conceal your identity. Isn't that correct?
I had an operation on my face to conceal my identity as a person of Japanese ancestry. I don't think it worked. At Tanforan, everyone knew me, and my folks didn't know the difference.
That's all I have, Your Honor.
Mr. Korematsu, you may step down.
With the evidence concluded, Collins renewed his motion to dismiss the charges. Judge St. Cyr again denied the motion and proceeded to announce his verdict.
Mr. Korematsu, please rise. The court hereby finds the defendant Fred Toyosaburo Korematsu guilty as charged. It is ordered that the defendant be placed on probation for a period of 5 years. It is further ordered that pronouncing of judgment be suspended.
Although Fred had been sentenced to probation and therefore would ordinarily have been permitted to go free, subject to supervision, the military police immediately took Fred into custody.
Fred was escorted back to Tanforan, where he was detained until his transfer with his family to Topaz. Collins filed a notice of appeal, but the government moved to dismiss, arguing that the suspended probationary sentence imposed on Fred was not final and therefore not subject to immediate appeal.
The motion to dismiss was heard by the Ninth Circuit the same day as the appeals of 2 other Nisei who had violated General DeWitt's orders. Minoru Yasui was a 25-year-old attorney in Portland, Oregon, when the curfew order came down. Unable to find a client willing to contest the curfew, he contested it himself and was convicted of its violation. Gordon Hirabayashi was a 24-year-old senior at the University of Washington. He was convicted of violating both the curfew and the order for exclusion.
After hearing argument, the Ninth Circuit passed the issues on to the Supreme Court. In Fred's case, that meant asking the court whether his sentence was appealable. The Supreme Court responded by determining to hear the Yasui and Hirabayashi cases and by allowing Fred's appeal to proceed.
The Hirabayashi and Yasui cases were decided by the Supreme Court on the same day. In Hirabayashi, the court unanimously upheld the curfew order, choosing not to decide the challenge to the evacuation order because the sentences ran concurrently. Chief Justice Harlan Fiske Stone delivered the opinion of the court.
We cannot close our eyes to the fact that in time of war, residents having ethnic affiliations with an invading enemy may be a greater source of danger than those of a different ancestry. Nor can we deny that Congress and the military authorities, acting with its authorization, have constitutional power to appraise the danger in light of facts of public notoriety. We need not now attempt to define the ultimate boundaries of the war power. We decide only that the curfew order as applied and at the time it was applied was within the boundaries of the war power. In this case, it is enough that circumstances within the knowledge of these charged with the responsibility for maintaining the national defense afforded a rational basis for the decision that they made. Whether we would have made it is irrelevant.
On this basis, the Supreme Court affirmed both Hirabayashi's conviction and Yasui's. On December 2nd, 1943, the Ninth Circuit affirmed Fred's conviction without hearing further argument. Circuit Judge Denman filed a concurrence objecting to the majority's cursory treatment of the matter.
In this conspicuous appeal of a member of one of America's minority groups, the opinion of this court disposes of Korematsu's major contentions without their mention, much less their consideration. Americans are to face a peace table at which our prestige and power will rest upon the belief of a world questioning Caucasian sincerity, a world which includes 1 billion Asiatics. There no one will shut his eyes to the Postons, Manzanars, and Tanforans. One of the questions will be what sort of judicial consideration do minority groups of American citizens receive from the courts of acclaimed democracy?
Fred's petition for certiorari was granted by the Supreme Court on March 27, 1944. An oral argument was set for the beginning of the next term.
In the meantime, in January 1944, General DeWitt's so-called final report on the evacuation of Japanese Americans from the West Coast was made public. The Justice Department attorneys working on Hirabayashi and Yasui had learned of the report as early as April 1943, but were not given access to it by the general's legal staff. Much like the written recommendation that led to Executive Order 9066, DeWitt's final report relied heavily on racial stereotypes and speculation. The report became a focal point of briefing and oral argument before the Supreme Court.
The Supreme Court heard argument over the course of 2 days, on October 11 and 12, 1944, before a packed courtroom. Collins argued on behalf of Fred, although he shared his time with Charles Horsky, a Washington, D.C. attorney. Charles Fahey, the Solicitor General of the United States, argued for the government.
Prior to 1955, the Supreme Court did not record or transcribe oral arguments as a matter of course, and lawyers who wanted a transcript of their arguments had to hire their own stenographer. Although the transcript did not come to light until 1985, Fahey had his argument transcribed in the Korematsu case. No transcript was made of the arguments presented on behalf of Fred. The following is a reconstruction of those arguments drawn from the briefs and accounts of observers, followed by excerpts from the Fahey transcript.
On Fred's behalf, his lawyers argued principally that the removal orders were unconstitutional because they were not based on any genuine military necessity and that the exclusion program was in reality a detention program. All rise.
May be seated.
Mr. Chief Justice, and may it please the court. Can a loyal American citizen be branded a criminal for resisting military orders that banished him from his home and imprisoned him in a concentration camp solely because of his ancestry? The answer, Your Honors, is no. When Mr. Korematsu was ordered to report for evacuation, there was no military necessity for exclusion. The government asks this court to take judicial notice of General DeWitt's final report, even though it recites so-called facts that were never placed in evidence during Mr. Korematsu's trial. It contains only unsupported allegations that Japanese Americans committed acts of sabotage and espionage. It was the prevention of these acts that was the purported rationale for the issuance of Executive Order 9066 and the curfew and exclusion orders. But there is no evidence of any such acts by Japanese Americans, not a single one.
Mr. Collins, did Mr. Korematsu conceitedly, quote, remain in, end quote, a restricted area after notice to him that he was required to leave?
Mr. Chief Justice, the only place Mr. Korematsu could lawfully remain in was the assembly center to which all Japanese Americans in that area were required to report, and from which they would be shipped to a relocation center. In both the assembly center and the relocation center, Mr. Korematsu would have been under detention, a word that does not appear in either Executive Order 9066 or Public Law 503. That detention, indefinite in duration, deprived Mr. Korematsu of his liberty without due process of law in violation of the Fifth Amendment, all in the name of non-existent military necessity. The final report does not rely on facts, but on hearsay and assumptions that the Japanese is an enemy race.
Does your argument come to this, that there is no rational basis for the exclusion order? Can we say that there were no other facts that General DeWitt knew?
The final report, Justice Frankfurter, does not contain any facts, only allegations, only unsupported allegations.
How are we to say that General DeWitt did not have any other facts?
Justice Jackson, the government admits in its brief that General DeWitt based his military judgment on tendencies and probabilities as evidenced by attitudes, opinions, and slight experience, rather than a conclusion based upon objectively ascertainable facts. I respectfully submit that such a conjectural and unsubstantiated statement meets no standard that comports with the Constitution.
Mr. Horsky.
May it please the court, and I direct the court's attention to the extraordinary footnote in the government's brief, and I quote, "We have specifically recited in this brief the facts relating to the justification for the evacuation, of which we ask the court to take judicial notice, and we rely upon the final report only to the extent that it relates to such facts. If the government expects the court to rely on the final report, surely more is required. The argument of military necessity reflects no more than General DeWitt's claim the Japanese Americans are members of an enemy race and predisposed by their racial characteristics to disloyalty. We urge the court to reject this claim, to reverse the conviction of Mr. Korematsu, and to restore to him and all Japanese Americans still held in detention the constitutional rights that all Americans of whatever ancestry are entitled to enjoy."
Solicitor Fahey, you may proceed.
May it please the court. It has been suggested by counsel that when the court held in Hirabayashi that the orders were justified under the exercise of the war power, it did not then have before it all the facts, and that now we know that the facts did not justify evacuation as a military measure.
Is it argued that there was no basis on which the military judgment could be founded?
It must be that, because that is the test. The final report of General DeWitt was upheld to your honors yesterday as proving that he himself had no rational basis on which to make a military judgment. I am not going into the details of that report because no doubt the court will read it. However, I do assert that there is not a single line, a single word, or a single syllable in that report which in any way justifies the statement that General DeWitt did not believe he had and did not have a sufficient basis in honesty and good faith to believe that the measures which he took were required as a military necessity in protection of the West Coast. It is even suggested that because of some footnote in our brief indicating that we do not ask the court to take judicial notice of the truth of every recitation in the final report of General DeWitt, that the government has repudiated the military necessity of the evacuation. It seems to me, if the court please, that this is a neat little piece of fancy dancing. There's nothing in the brief of the government which is any different from the position it has always maintained since the Hirabayashi case, that not only the military judgment of the general, but the judgment of the government of the United States has always been in justification of the measures taken, and no person in any responsible position has ever taken a contrary position, and the government does not do so now. Nothing in its brief can validly be used to the contrary.
As I understand the argument of the other side, it was that this report taken as a whole could be taken to exclude the possibility of a basis for military judgment to continue these exclusion orders.
Yes, that is their position.
Do you challenge that position?
We say that the report proves the basis for the exclusion orders. There is not a line in it that can be taken any other way.
Suppose the commanding general, when he issued order number 34, had said in effect, "It is my judgment that as a matter of security, there is no danger from the Japanese operations, but under cover of war, I had the authority to take advantage of my hostilities and clear the Japanese from this area." Suppose he had said that with that kind of crude candor. It would not have been within his authority, would it?
It would not have been. But, Your Honors, if I may, I wish to explain what happened so that the court can judge the matter of detention. These people were not prisoners. They were not in concentration camps. These are the facts. An effort was made by the general to have these persons voluntarily migrate. Out of the 112,000, only about 5,000 left. Then the general tried another method, setting a deadline and saying, if you don't go within a certain period voluntarily, then you will be moved. That did not work. In addition, at that time, a great wall of hostility grew up in the bordering states when they were faced with this great migration of persons of Japanese ancestry. The civilian authority devoted itself to working out the problem in humanity and decency. Our opponents suggested that General DeWitt in his final report says that from a purely military standpoint, all that was necessary was that these people be required to leave, that detention was unnecessary. What does that amount to? Did they desire the government to run them out at the point of bayonet, to force them into the desert and into the mountains, old men, old women, babies in arms, and children, into a hostile area, unprovided for, without transportation, without shelter, without food, and without protection? The government of the United States had the right to move these people. Does the Bill of Rights require that it drive them out of the area like a herd of cattle? The stern hand of the government, which took hold, brought about the evacuation. It had a right, a duty, and a responsibility. But if that were to be done, the stern hand could turn somewhat, as it did, into a gentle hand, to control this in a manner befitting this government of ours. That was the reason for the detention.
Do you suggest any ground on which this court could say that you can detain these people in the way they were detained in a relocation center?
Temporarily during evacuation, yes.
That would not justify detaining them permanently if hostility to them should continue.
That is correct, Your Honor.
Where would detention to protect them end? What will ever terminate this business?
Your Honor, detention in the assembly centers, as I have pointed out, was a method of accomplishing evacuation.
It is one thing to submit to imprisonment to go through a period of sifting to determine one's loyalty to his country. It may be an entirely different thing to submit to indefinite imprisonment without any opportunity for such sifting to take place.
These people suffered hardships and inconveniences and temporary deprivation of their liberties and freedom, but it must be viewed in the perspective of this whole war. Millions of people, including hundreds of thousands of our own citizens, have already become casualties of the war. This program should not, under the Bill of Rights, be looked at as isolated from the whole of which it is part. These citizens have been taken care of in the best manner under the circumstances that a fair and efficient government could possibly bring about. Those who have been injured, as many have temporarily, should be asked to view the situation along with the great injuries, losses, suffering, and hardships of millions of our own people in the fight of the nation for its life. Once you establish to your own satisfaction that this was part of a necessary military measure to ward off the threat caused by the eruption of the Japanese in combination with Hitler to destroy the very life of the nation, you get a true perspective of the problem.
On December 18, 1944, the court rejected Fred Korematsu's challenge to the exclusion order, citing Hirabayashi. Justice Black wrote for the majority.
We uphold the exclusion order. In doing so, we are not unmindful of the hardships imposed by it upon a large group of American citizens. But hardships are a part of war, and war is an aggregation of hardships. All citizens alike, both in and out of uniform, feel the impact of war in greater or lesser measure. Citizenship has its responsibilities as well as its privileges, and in time of war, the burden is always heavier. Korematsu was not excluded from the military area because of hostility to him or his race. He was excluded because we are at war with the Japanese Empire, because the properly constituted military authorities feared an invasion of the West Coast and felt constrained to take proper security measures, because they decided the military urgency of the situation demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily, and finally, because Congress, reposing its confidence in this time of war in our military leaders, as inevitably it must, determined that they should have the power to do just that. There was evidence of disloyalty on the part of some. The military authorities considered that the need for action was great and time was short. We cannot, by availing ourselves of the calm perspective of hindsight, now say that at the time these actions were unjustified.
3 justices wrote dissenting opinions. First, Justice Roberts.
I dissent because I think the indisputable facts exhibit a clear violation of constitutional rights. This is a case of convicting a citizen as a punishment for not submitting to imprisonment in a concentration camp based on his ancestry and solely because of his ancestry without evidence or inquiry concerning his loyalty and good disposition towards the United States. I would reverse the judgment of conviction.
Next, Justice Murphy.
This exclusion of all persons of Japanese ancestry, both alien and non-alien, from the Pacific Coast area on a plea of military necessity in the absence of martial law ought not be approved. Such exclusion goes over the very brink of constitutional power and falls into the ugly abyss of racism. No adequate reason is given for the failure to treat these Japanese Americans on an individual basis by holding investigations and hearings to separate the loyal from the disloyal, as was done in the case of persons of German and Italian ancestry. It is asserted merely that the loyalties of this group were unknown at the time, and time was of the essence. I dissent from this legalization of racism. Racial discrimination in any form and in any degree has no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but it is utterly revolting among a free people who have embraced the principles set forth in the Constitution. All residents of this nation are kin in some way, by blood or culture, to a foreign land. Yet, they are primarily and necessarily a part of the new and distinct civilization of the United States. They must, accordingly, be treated at all times as the heirs of the American experiment and as entitled to all the rights and freedoms guaranteed by the Constitution.
And finally, Justice Jackson.
Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born, and where all his life he has lived. Now, if any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. But here is an attempt to make an otherwise innocent act a crime merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race from which there is no way to resign. Much is said of the danger to liberty from the Army program for detaining these citizens of Japanese extraction. But a judicial construction of the Due Process Clause that will sustain this order is a far more subtle blow to liberty than the promulgation of the order itself. Once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. I do not suggest that the court should have attempted to interfere with the Army in its task, but I do not think they may be asked to execute a military judgment that has no place in the law under the Constitution. I would reverse the judgment and release the prisoner.
All rise.
When Ernest Bessig wrote to tell Fred of the decision, Fred was working in Detroit, Michigan, near his brothers. While his application for indefinite leave from Topaz had been granted, his parents were still interned there. Years later, Fred described his reaction.
I received a letter from Mr. Bessig, and he told me that we lost in the Supreme Court. And I just couldn't believe it. It seemed like the bottom dropped out. I just felt like, am I an American or not?
Fred wrote back to Bessig to thank him, the ACLU, and Wayne Collins, and then set the case to one side for decades. In October 1946, Fred married Catherine Pearson, a woman of English, German, Irish extraction, who had earned a master's degree in medical technology and who had heard of Fred's case long before she met him. Her recollection was that he was never bitter about it, but Fred later admitted that he never gave up hope that someday he would again be able to challenge his conviction.
In the meantime, Fred needed to start his life over, as did the other Japanese Americans who had been sent to the camps. Striving to put the camp experience behind them, many Nisei, including Fred, avoided discussing it, even with their own children.
I was going to talk to them. And you know, when they're growing up, when they're teenagers, and Karen was involved in Girl Scouts, involved in being a cheerleader at the high school, and they come in and go out right away. They come in and change clothes and off they go, and so forth. And then on top of that, I bought a house, and in order to maintain it, I had to have 2 jobs, so I was busy myself. So before you knew it, the time just flew.
As a result, both Fred's children, Karen and Ken, found out about their father's case as juniors in high school in history class. When Karen confronted Fred, she was struck by how painful it was for him to tell her that, yes, his case had gone to the Supreme Court, but he still had a criminal record. She did not pursue the conversation.
For Fred, rebuilding was particularly difficult. His criminal record made it hard for him to find a job, and his case was, for many Japanese Americans, a source of shame. Within his own family, there were difficulties. When his mother died in 1951, his sister-in-law told Fred that her death was his fault. The family thought she had developed ulcers because of Fred's case.
Gradually, however, Japanese Americans began to press for relief. In America's bicentennial year, 1976, President Gerald Ford formally terminated Executive Order 9066, acknowledging the need for the nation to recognize our national mistakes so as to avoid repeating them. On July 31, 1980, President Jimmy Carter signed legislation establishing the Commission on Wartime Relocation and Internment of Civilians to investigate the claim that the incarceration of Japanese Americans during World War II was justified by military necessity. The commission held 20 days of hearings and heard from 750 witnesses. Although Fred's case was the subject of testimony, Fred himself chose not to testify. His hope was still to somehow reopen his case, but he could not imagine how.
Finally, in January 1982, he received a call and then a visit from Professor Peter Irons. Working with a Nisei woman who had herself been incarcerated during the war, Aiko Herzig Yoshinaga, Professor Irons had discovered documents showing that the government had purposefully withheld and altered information presented to the Supreme Court. One critical document was a memo to Solicitor General Fahey from the Justice Department attorney in charge of drafting the Korematsu brief. Edward Ennis had located a memo written by a naval intelligence officer, Lieutenant Commander Ringel, who had advised before Executive Order 9066 was issued that 90% of the evacuation was unnecessary. In his memo to Fahey, Ennis expressed his concern.
In one of the crucial points of the case, the government is forced to argue that individual, selective evacuation would have been impractical and insufficient when we have positive knowledge that the only intelligence agency responsible for advising General DeWitt gave him advice directly to the contrary. In view of this fact, I think we should consider very carefully whether we do not have a duty to advise the court of the existence of the Ringel Memorandum and of the fact that this represents the view of the Office of Naval Intelligence. It occurs to me that any other course of conduct might approximate the suppression of evidence.
As we have seen, Ennis was overruled, and the government persisted in arguing military necessity on the basis of DeWitt's final report. In fact, before submission to the Supreme Court, the final report was altered to more closely track the government's arguments, and the footnote discussed that oral argument was a rewritten version of what was originally intended by Ennis to be a request that the court not take judicial notice of the so-called facts in the report. When Professor Irons met with Fred, he explained that there were documents that might enable Fred to reopen his case and handed him a sample. Fred looked through them, page by page, and then he had a fundamental question for the professor.
They did me a great wrong. Are you a lawyer?
Yes, I am.
Would you be my lawyer?
I'd be glad to, but I can't do this alone.
Irons had also obtained consent from Minoru Yasui in Portland and Gordon Hirabayashi in Seattle to reopen their cases. And soon, 3 legal teams, comprised principally of third-generation Japanese Americans, were hard at work. Dale Manami became lead counsel for the Korematsu case and coordinating counsel for all 3 cases. Years later, he recalled how the teams came together. After Professor Irons contacted him, he called colleagues in the civil rights arena and received enthusiastic responses from attorneys eager to challenge their parents' incarceration.
The connections we make early in our life become real and important when you need to reach out for allies. That was the salvation in our cases, so it wasn't an accident that the legal teams magically appeared. It was because of connections which then allowed Catherine Banai and Peggy Nagai and Rod Kawakami to recruit a host of attorneys and take the enormous risks of handling monumental civil rights cases pro bono while struggling to make livings as private attorneys in their own firms.
Joined by volunteers like Don Tamaki, then director of the Asian Law Caucus, Eric Yamamoto, who declined partnership in a Hawaii law firm to join the group, and Ed Chen, then at the ACLU, the group developed an overall effort on behalf of Fred, Hirabayashi, and Yasui that relied on an arcane and little-used procedural vehicle. Professor Irons suggested that petitions for a writ of error coram nobis could be brought, a possibility raised at a commission hearing by Judge William Maritani of the Philadelphia Common Pleas Court, who had himself been in prison during the war and was the only Japanese American on the Commission on Wartime Relocation. Such petitions seek relief from criminal convictions already served on the basis of errors of the most fundamental nature, amounting to manifest injustice.
The Korematsu petition was filed on January 19, 1983. The matter was assigned to Judge Marilyn Hall Patel, who had been nominated for the federal bench by President Jimmy Carter. The government's lawyer was Victor Stone of the Justice Department, who repeatedly sought more time to respond to the petition. The Commission on Wartime Relocation published its report in February 1983, entitled Personal Justice Denied, concluding that Executive Order 9066 was not justified by military necessity and that a grave injustice was done to American citizens and resident aliens of Japanese ancestry. The government was allowed to defer response to Fred's petition until after the Commission issued its formal recommendation.
When the Commission did so on June 16th, it included a recommendation of pardons. When Stone called saying that he might be able to offer a pardon for innocence, Fred's lawyers went to talk to him. Fred had this response.
No, I won't accept a pardon. If anything, I should pardon the government. They were wrong.
The government finally responded on October 4th, 1983, agreeing that Fred's conviction should be vacated, but moving to dismiss the petition on the ground that it was not necessary for the court to address Fred's claims of government fraud. As the hearing date approached, Judge Patel made arrangements to move the proceedings to the court's ceremonial courtroom to accommodate the anticipated flood of spectators. All rise.
Please be seated.
On the date of the hearing, November 10, 1983, the courtroom was packed. The legal teams for all the coram nobis petitioners were present. Dale Manami, acted as lead counsel for Fred, Victor Stone appeared for the government. After first hearing argument on the government's motion to dismiss, Judge Patel stated as follows.
I conclude that it is inappropriate for the court to do anything with respect to the government's motion other than to treat it as essentially non-opposition to the petition. The court may look to the fact that the government has responded in a fashion that is tantamount to a confession of error, even though it has not admitted to various allegations in the petition. With respect to whether the petition should be granted, I will hear from you now, Mr. Minami.
Your Honor, we are here today to seek a measure of the justice denied to Fred Korematsu and the Japanese American community 40 years ago. This is not just a 40-year-old misdemeanor, as the government characterizes it. This is a monumental precedent which affected deeply and irrevocably the lives of 100,000 Japanese Americans by sanctioning the mass banishment of a single racial minority group. This case also established some of the most criticized and controversial precedents in legal history. Korematsu versus United States has never been overruled and has never been reversed. Today, we know that this Supreme Court decision rests on a non-existent factual foundation. Evidence we have presented in this case underscores this assertion. The government, however, is arguing, in essence, that we should put the controversy behind us and that we should, in a sense, let all wounds heal. But whose wounds need healing? The Japanese Americans who have lived with the stigma of this decision for 40 years? Or is it the wounds of guilt of high government officials who were responsible for this great civil rights disaster? This attitude of the government is precisely why a judicial declaration of the grounds for granting a petition is necessary, because this was not an unfortunate incident. This was not a mistake. This was a deliberate and calculated plan to exclude and imprison a single minority group. The public interest demands more than a sterile recitation that we should let bygones be bygones, and requires that the real reasons be exposed so that this tragedy will never be repeated for those Japanese Americans interned, for those ex-internees in the audience, for Korematsu, and for this court. This is the last opportunity to finally achieve the justice denied 40 years ago.
Thank you. Is there anything further, Mr. Minami?
If we may beg the court's indulgence, Mr. Korematsu would like to make a statement to the court.
I will allow him to do so at this time. Mr. Korematsu?
Your Honor, I still remember 40 years ago when I was handcuffed and arrested as a criminal. As an American citizen being put through this shame and embarrassment, and all Japanese American citizens who were escorted to concentration camps suffered the same embarrassment, we can never forget this incident as long as we live. The horse stalls that we stayed in were made for horses, not human beings. According to the Supreme Court decision, being an American citizen was not enough. They say you have to look like one. Otherwise, they say you can't tell the difference between a loyal and disloyal American. I thought that this decision was wrong, and I still feel that way. As long as my record stands in federal court, any American citizen can be held in prison or concentration camps without a trial or a hearing. That is, if they look like an enemy of our country. Therefore, I would like to see the government admit that they were wrong and do something about it, so that this will never happen again to any American citizen of any race, creed, or color.
Thank you, Mr. Korematsu. Does the government have a response at this time?
The government's response, Your Honor, is that many of the difficulties we have encountered emanate from the very same document which we have told the court that it could recognize exists, namely the Commission's report. To the extent that we are in a court of law and dealing with legal matters, that Commission's report is concluded, and we find ourselves, I think, unanimous in agreeing with it, that it says the decision in Korematsu lies overruled in the court of history. We don't think the decision lies around like a loaded gun, and to that end, the legislative and executive branches have repealed any authority that any underlying statutes might once have had. But the report did not reach the conclusion that there were particular acts of suppression by the government that might have occurred when the cases were litigated. In fact, it suggested exactly to the contrary.
Is the matter submitted for the court's ruling?
Yes, Your Honor.
That means the court would deny us any leave to file anything further?
Yes, and the reasons are as follows. The government has essentially responded with a non-response. I am not inclined to conduct full-blown hearings in order to support a finding which all parties agree would be appropriate. But I need not accept the meek acquiescence of the government and merely set aside the order without independently assessing the merits of the petition and the grounds for granting it. The Commission report, as well as the other exhibits that have been submitted by petitioner, show that the military necessity justification relied upon by the government in its arguments to the court and to the Supreme Court was based on unsubstantiated facts, distortions, and representations of at least one military commander whose views were seriously infected by racism. The court is satisfied that justice would indeed be done if the petition for a writ of coram nobis were granted, that the public interest is served granting the motion, and that the court's records themselves should be purged of a proceeding which was fundamentally unfair. I would caution all the parties and the persons in this courtroom that this court cannot, by wiping out this conviction, erase from the books the case of Korematsu versus United States. Perhaps the Korematsu decision, as has been referred to by the government, stands as an anachronism. I think legal scholars will agree to say it stands for very little, if anything, in the way of precedent. Perhaps what it stands for most of all is a caution that in times of war, military necessity, or national security, our institutions must be all the more vigilant in protecting constitutional guarantees. The conviction that was handed down in this court and affirmed by the Supreme Court in Korematsu versus United States is, by virtue of granting a writ of coram nobis today, vacated and the underlying indictment dismissed. I will prepare a memorandum decision that more fully explicates the order of the court that I have verbally stated from this bench. Thank you, counsel.
With that, the judge left the courtroom. No one had expected her to rule from the bench, and team members later described a veritable explosion of tears, smiles, hugs, and high fives. One team member recalled seeing the judge pause and smile as she surveyed the scene. The judge later explained that on this occasion, she wanted the people who attended to hear more than, "Thank you, counsel, the court reserves decision."
The government appealed, but asked leave to delay filing its brief until after the written opinion was issued. Once it was issued, the government withdrew its appeal.
After their victory, Fred and his legal team continued to support the other coram nobis cases. In Yasui's case, the judge agreed with Victor Stone that it was unnecessary to address the charges of government misconduct. Yasui died while his appeal was pending, and it was dismissed. In Hirabayashi's case, after a mixed ruling from the district court that both sides appealed, on September 26, 1987, the Ninth Circuit vacated his convictions. Fred traveled to Seattle to join in the celebration.
In the years that followed, Fred logged many more miles to assist in the redress effort and to talk about his case. When he first met with his legal team, he told them that he did not wish to speak. But once he saw that they needed to raise money to proceed, he felt he needed to support them and began at that point to speak at events. After he won, he did not stop speaking out.
Fred and Catherine worked with the National Coalition for Redress, Reparations, supporting the NCRR however they could. On August 10, 1988, President Ronald Reagan signed the Civil Liberties Act of 1988, which provided a formal apology and redress of $20,000 to each survivor. As Fred had been laid off from his job when he told his boss he had reopened his case, the money was a help to Fred.
From a shy man who didn't want to speak at all, Fred became an activist who tried never to turn down an invitation to address any audience, large or small.
Whenever I'm asked to make an appearance, I do, because I feel that there are so many people who don't know what happened. I want them to know. I hope this could never happen again. But it could.
Fred was not a polished speaker, but his audiences appreciated his plain-spoken words and his self-effacing modesty. He received countless awards, including the Presidential Medal of Freedom on January 15, 1998. In introducing Fred, President Bill Clinton described him as an ordinary American who took an extraordinary stand. As Quorum Nobis legal team member Lori Benai wrote in her book about Fred,
Fred's belief that he was and should be treated just like everyone else was what had driven his original decision to refuse the removal orders. He did not view himself as a hero or exceptional person. He simply did what he felt was right.
Fred died on March 30, 2005, at the age of 86, only 6 months after his op-ed piece appeared in the San Francisco Chronicle. Some 700 people attended his funeral service, including his legal team and Judge Patel. Catherine selected America the Beautiful for the final hymn, for its words about brotherhood from sea to shining sea. Team member Ed Chen later stated,
I told Catherine after the service that I would never hear that song quite the same again. It was so moving, at least in part because it described the American Fred envisioned, one true of its founding principles.
On May 20th, 2011, Neil Katyal, the first Asian American to act as Solicitor General of the United States, posted a statement on the Department of Justice's website. It was entitled, Confession of Error, the Solicitor General's Mistakes During the Japanese-American Internment Cases. Katyal thereby issued the department's first public acknowledgement of the mistakes made by his predecessor.
Hiding the truth from the justices harmed the court, and it harmed 120,000 Japanese Americans. It harmed our reputation as lawyers and as human beings, and it harmed our commitment to those words on the court's building: equal justice under law.
While Fred would surely have welcomed such a public confession of error, he would also have recognized that his mission was not yet accomplished. At that time, the Supreme Court's decision in his case was viewed as thoroughly discredited, but it had not been overturned and was arguably still the loaded weapon so of concern to Justice Jackson.
Could concentration camps be built again in America? That is what Fred feared, and that is what he fought to prevent. His team of Quorum Nobis lawyers have carried on his efforts in their own ways. Dale Manami continues his work on civil rights cases with his partner, Don Tamaki. Eric Yamamoto teaches law students at the University of Hawaii's Richardson School of Law as its inaugural Fred T. Korematsu Professor of Law and Social Justice. Lori Benai teaches as well as a professor at Seattle University School of Law. Ed Chen is now a federal judge, serving in the same district where Judge Patel presided over the Korematsu case.
Founded by Fred's daughter, Karen Korematsu, the Fred T. Korematsu Institute in San Francisco has carried on his work of telling the story of the Japanese-American experience in World War II. Through Karen's efforts, 10 states have recognized January 30, Fred's birthday, as Fred Korematsu Day. On December 19, 2017, the City Council of New York City established January 30 annually as Fred T. Korematsu Day of Civil Liberties and the Constitution. As the City Council recognized in its resolution, Fred's courage in fighting for justice and civil liberties furthered the cause of equality for Asian Americans and made him an inspiration for all Americans.
Karen and the Institute have taken on Fred's mission to, as she puts it, remind Americans what happens when our Constitution is ignored in the name of national security. In furtherance of that mission, she, with the children of Gordon Hirabayashi and Min Yasui, asked the Supreme Court to reject President Trump's executive orders banning immigration from predominantly Muslim countries and to repudiate its decisions in their fathers' cases. On June 26, 2018, the Supreme Court ruled on the third version of the travel bans in Trump v. Hawaii. In his majority opinion, Justice Roberts upheld the travel ban, but addressed the Korematsu case as follows, closing with a quote from Justice Jackson's dissenting opinion.
The dissent invokes Korematsu versus United States. Whatever theoretical advantage this dissent may see in doing so, Korematsu has nothing to do with this case. The forcible relocation of United States citizens to concentration camps solely and explicitly on the basis of race is objectively unlawful and outside the scope of presidential authority. But it is wholly inapt to liken that morally repugnant order to a facially neutral policy denying certain foreign nationals the privilege of admission. The dissent references to Korematsu, however, affords this court the opportunity to make express what is already obvious. Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution.
In her dissent, joined by Justice Ruth Bader Ginsburg, Justice Sotomayor wrote as follows.
In the intervening years since Korematsu, our nation has done much to leave its sordid legacy behind. Today, the court takes the important step of finally overruling Korematsu. This formal repudiation of a shameful precedent is laudable and long overdue, but it does not make the majority's decision here acceptable or right. By blindly accepting the government's misguided invitation to sanction a discriminatory policy motivated by animosity toward a disfavored group, all in the name of a superficial claim of national security, the court redeploys the same dangerous logic underlying Korematsu and merely replaces one gravely wrong decision with another. Our Constitution demands, and our country deserves, a judiciary willing to hold the coordinate branches to account when they defy our most sacred legal commitments. Because the court's decision today has failed in that respect, with profound regret, I dissent.
Two days later, the New York Times published an op-ed by Karen Korematsu. Karen wrote as follows.
On Tuesday, the Supreme Court got it partly right. After nearly 75 years, the court officially overruled Korematsu versus United States. But the court's repudiation of the Korematsu decision tells only half the story. Although it correctly rejected the abhorrent race-based relocation and incarceration of Japanese Americans, it failed to recognize and reject the rationale that led to that infamous decision. My father spent his life fighting for justice and educating people about the inhumanity of the Japanese American incarceration so that we would learn from our mistakes. Although he would be somewhat glad that his case was finally overruled, he would be upset that it was cited while upholding discrimination against another marginalized group. The court's decision replaced one injustice with another nearly 75 years later. My father would still say, "Stand up for what is right."
Thank you very much. I'm Denny Chin, otherwise known as narrator number 1, and this is
Kathy Chen, also known as narrator number 2, and his wife.
Yeah, if you were wondering, Kathy and I are indeed husband and wife, and we've been doing these reenactments for about 12 years now with the Asian American Bar Association of New York. We've taken historic cases and tried to find the actual transcripts and other original documents, and we put them into a play, a one-hour play. This one ran a little bit longer because we had to update it, rewrite the ending with the travel ban decision from last year. These are great teaching tools. We have a team of lawyers and judges in New York City with the Asian American Bar Association of New York. Anna Mercado, who helped organize all of this, by the way, together with the support of the Jackson Center, is on our team. And we come up with cases, we do the research, we find the transcripts, and then we write them into these plays. And we try to pick cases that raise issues that are still important today. The Asian American Bar Association has a website on the trial reenactments that describes our cases. The Second Circuit, the court of which I am a member, has stolen the idea and created a similar website. And the concept is that schools, bar associations, community groups can email in and request scripts and then take them back to their communities to do them. This is the 7th or 8th time that we are doing this Korematsu presentation, which we only wrote a couple of years ago. You heard Karen talk about it. But this will prove to be a very popular one. One of our scripts, The Murder of Vincent Chin in Detroit in the early 1980s, has been presented more than 30 times all around the country, including by, for example, the Department of Justice. And Kathy and I actually traveled to Switzerland to do it with an international cast at one point. So you should feel free to check out the websites and to check out the different programs. We're going to leave the heavy stuff to Professor Barrett, but if anyone has any questions about the format or how we put this one together, we'd be happy to answer a couple of questions. Did you want to add anything before?
Well, we should probably mention that when people borrow the scripts from the website, we also give them access to the slides. And I think the slides do add something to the presentation. Being able to actually see the faces of the people who spoke those lines so many years ago makes it a little bit special, because we're just a bunch of lawyers standing around reading from a script. To actually see the people on the screen, I think helps.
Yeah, and the cast, I mean, today's cast was put together by Anna and others at her law firm. And Kathy and I just came in at the last moment, but we had Justice Jackson's grandson playing Justice Jackson. And part of the benefit of these programs is having different people participate in the cast. One last thing. Kathy and I actually saw the documentary for the first time last night, and it's pretty remarkable how many of the lines and the scenes are the same. But we did not steal them from the documentary. We came up with them independently, but it was good to see that at least we were thinking along the same line.